everyone, welcome back to our video series, Legalese Translator. My name is Heather Hui-Litwin, and joining me here again, of course, is Heather Douglas. Hi, Heather.
Hi.
So in this video, we're going to talk about two words again. It's the word shall and it's the word may. And so when you read the rules of civil procedure, sometimes it says the court shall do something, and then at other times says the court may. Now, Heather, can you explain to us a little bit about the distinction? What does each word really means?
So shall means it must happen.
Okay.
So if the rules say that on such and such a date something shall happen, then that means you must do it. If it says may, then there's some discretion about whether it can be done or not. For example,
okay.
Sometimes a law may say this, if found guilty, then there shall be a sentence of 5 years. So that would mean that the judge wouldn't have the discretion to give someone more or less than 5 years. They would have to give 5 years. If it said, if they're found guilty, then the penalty may be up to 5 years, then that means the judge would have the discretion, the ability to decide whether he or she wanted to give 1 year, 2 years, 3 years, 4 years, or 5 years. So with shall, it must be done. If it's may, then it means it can be done, but doesn't have to be.
So a couple of questions. I know that, for example, Rule 48.14, there's something called, I think it's called an administrative dismissal for delay, which is if a lawsuit has been sitting around and nobody's really doing anything with it, it's not active, it's been sitting around, the court seems to have the power to just throw it out. I guess that's a way to put it. So here, if I just read a little bit of the rule to you, because I have a question, it says, unless the court orders otherwise, the registrar shall dismiss, that word, shall dismiss an action for delay in a couple of circumstances. So one circumstance is that if it has not been set down for trial or terminated by any means by the 5th anniversary since the commencement of the action. Okay, so let's just for our explanation today, for today's sake, I'm just going to focus on this first part. So if the lawsuit has not been finished or set down for trial by the 5th year, sounds like that's what it's saying, the 5th year since the lawsuit started, it says that the registrar shall dismiss it. So when I'm reading that, does that mean that that if a lawsuit's been just going to hang around, that it will be automatically dismissed?
Essentially, it means it should be dismissed. The court should do it. Yeah. But whether or not the staff actually get to dismissing your action is a totally separate question. But yeah, it means it has to be done.
Okay.
But this is an interesting rule because if it does happen, if you are the plaintiff and you find that your action has been dismissed automatically, then you can bring a motion to the court to get that dismissal set aside. And usually, but not always, the court will set aside the dismissal because ultimately courts are interested in having lawsuits decided on the merits as opposed to a procedural issue.
Interesting. So if I were a defendant, I shouldn't be too complacent. I guess I shouldn't assume that the court is going to dismiss my opponent's lawsuit and then I'm free. It's not that easy, is it?
Yeah, you should still take steps to build your case and not just rely on the dismissal by the 5th year.
Okay. Now, Now, another question, which is the final question. I'm just wondering what happens. Now, I know that sometimes in the rules it says that the parties are supposed to do certain things at certain times. And one of the examples is discovery plan. The rule 29.1.03, sub 2 is saying that parties shall agree to a discovery plan before 60 days after the close of pleadings. So I'm reading this rule and I'm thinking, oh, okay, so the parties, they must agree to have a discovery plan in place. But so what? Like I'm saying, so what? Like what happens? Let's suppose the other side drag their feet and they just never talk to you. They never call you. They never do anything to continue the lawsuit. What happens? Are there any adverse consequences? Like,
so let's say you are not able to come to an agreement, then you can bring a motion to the court and have a judge or a master make a ruling on the discovery plan. However, with the discovery plan in certain areas of law, there might be a culture amongst the lawyers that the 60 days is kind of relaxed and they might not abide by it very strictly. So in some areas, lawyers might not bring a motion on the 61st day immediately after it's happened to try to get a discovery plan enforced. Doesn't mean it won't happen, but sometimes the lawyers might have a culture of following some rules less strictly as others.
I see. Oh, that's really interesting. Okay, so just because sometimes if the rules say something in black and white, in reality, it doesn't quite translate, right, to something that's so rigid that things must be done, the discovery plan must be in place before the 60 days. And it really just depends on the culture, that's what you're saying, of the lawyer.
Exactly. If I was dealing with another lawyer and we weren't able to come to an agreement on the discovery plan and day 61 hit, I wouldn't bring my motion, I wouldn't serve them with a motion on day 62. I would probably see if I can come to an agreement over the next week or so or something. And if you cannot come to an agreement and there's been lots of correspondence back and forth and there's a really, really important issue that you want in that discovery plan, then that's the time to bring your motion. But litigants should keep in mind that the courts are always there to hear your disputes, but if you can cooperate and come to an agreement, then that's ideal.
Right. So the last word I think we should, that people should know is that always try to be reasonable and be civil with each other.
Exactly.
Okay. Well, thank you very much, Heather, for clearing that up, and also for bringing your insight, because it's just really interesting to find out what actually happens in real life in lawsuits, as opposed to just reading the rules at home. Well, thank you very much, and thank you everyone for watching. Don't forget to hit subscribe if you're new to the channel, and we'll see you at the next video. Thanks. Bye.
Bye.